The Beasley Allen Report with your host Gibson Vance and special guest attorneys and legal experts discussing the important legal issues that affect you. Brought to you by the Beasley Allen Law Firm, one of the largest personal injury firms in the nation, and founded by former Lieutenant Governor Jere Beasley. This is the Beasley Allen Report. Now, here's your host, Gibson Vance.
Welcome to the Beasley Allen Report. This year, the Beasley Allen Law Firm celebrates our 35-year anniversary. And to commemorate our anniversary, former Lieutenant Governor and Beasley Allen founder Jere Beasley joins me to discuss two important cases that stand out over the years. These cases were instrumental in bringing safety changes in the way automobiles and tractors are designed. Jere, welcome back to the show.
Thank you, Gibson. It's real good to be back. And in fact, it's hard to believe it's been 35 years since the firm was started, but time flies.
Well, to put that in perspective, Jere, we know what the firm looks like today. We have close to 80 lawyers, about 200 support staff folks, but when you started in 1979, it didn't look exactly the same.
In fact, when I started the firm, we had one lawyer, and that was me, one secretary, and one legal assistant. No clients, and we started over on Hull Street, building owned by Irving Winter, and we really started from scratch. I had tried to get a job with a lot of other law firms in Montgomery. Nobody would hire me, and looking back, I would have hired myself at that point. So I can't really complain, and I didn't get mad. Didn't really get disappointed. I just decided the best thing to do was give it a shot. We opened the office, prayed about it a lot, and ended up growing into where we are now, because we've been blessed without question.
Well, you had been Lieutenant Governor for 8 years prior to opening your own office, and you rented a spot, as you said, on Hull Street, and we've emerged into one of the largest plaintiffs' law firms in the country. What would you deem as the secret to the success of the firm?
Well, I've always felt like that we did it the right way and did it for the right reason, and that combination generally works. We put the client's interest first, we keep it there, and when it's over, our goal is to make sure that when a client leaves our office, they're in better shape than they were when they came. And so far, that's generally been the case.
I know when you first started the practice, you worked a lot on personal injury product liability cases, and we're going to talk about some of those over the last few years that are really notable. But you also segued into a lot of consumer fraud type cases, and that brings me to the case that's gotten a lot of publicity, not just here or across the country, but really across the world, and that is the Target case. I know you're working on that case. Tell us a little bit about it.
Well, Dee Miles and Larry Golson in our firm are the lead lawyers in this litigation. We filed class actions, an individual class and also one for financial institutions. Target was hit, they were hacked into, a lot of personal information was obtained. How much, we really don't know. I don't think Target has been quite up front on exactly what happened. For example, they finally had to admit over 110 million customers had at least the potential to have their card information, their personal information, which is very sensitive, stolen.
You know, that is really important to people watching this show. We have about 10,000 people watch us on Sunday evenings, and I know my wife, for one, is going to go to Target 2 or 3 times a week, and it's a lesson, and WSFA did a great story about it, is how to make sure that your financial data is more secure, but we've never seen a case as big as Target.
It's going to be extremely large, and unfortunately Target may not be the only retailer that was hit. And the point that has to be made is that these companies have got to protect the consumers. They have to protect the people that come into their stores. There are things that they can do, and many of them have not done it. And we are hoping that this case will bring, it has brought a great deal of attention and brought the issue to the forefront. And I believe you're going to see some significant changes, Gibson, in the way credit cards are used in retail establishments.
You know, Jere, as we go through this case of Target, it's always the same. You usually find out that the store or the business knows that there is a problem. In this case, we're going to find we know or they knew that they were vulnerable to this type of attack, but yet they didn't do what they needed to do to protect the consumers?
Well, for example, in Europe, they do it much differently there. They protect the card holder much better than we do here. That's why the bad guys are targeting the United States. They're not targeting Great Britain. They're not targeting the European countries. And I believe you're going to see some significant changes here. A lot of people don't realize it, but the banks have claims also. Credit unions, banks, they're having to go back and reissue credit cards and on a daily basis furnish information to people who call in about their bank accounts, their credit card activity. And it's a monumental problem for the financial institutions in addition to the consumer, the card holder.
Well, I know our firm represents several financial institutions, banks, credit companies, and the bottom line there is that these banks, especially the small town banks, it's a nightmare for them. As you mentioned, they're having to do so much work to try to protect the folks that Target wasn't able to protect. Well, we're going to talk a lot on this show today about a couple of product liability cases that our firm has handled, and we're going to do that right after this very short break. You're watching the Beasley Allen Report. We'll be back in just a minute.
The Beasley Allen Law Firm, helping those who need it most since 1979.
Everybody that comes to us, they have a problem of some sort. Oftentimes it's a death, oftentimes a very serious injury, terrific economic losses, disability. And you got to get to know the clients, and you really got to know who they are, know their families, know where they came from, their lifestyles, and you really just want to put yourself in a position to, when they leave this office, they'll be in much better shape than when they got here. And we just want to put them back as close to where they were before the event happened that brought them to us. And we have worked hard to make sure that we really help folks. And we don't represent any of the big corporations. We don't try to represent them. We want to help folks who need help.
Helping those who need it most since 1979. At Beasley Allen, our motto says it all. We not only serve others in the courtroom, but through our cases, we make a difference for people throughout the country. Our victories often result in corporations creating safer workplaces and manufacturers making safety changes in their products. The Beasley Allen attorneys, investigators, and support staff work together to find the hidden cause behind an accident or injury. See how Beasley Allen has been helping others at BeasleyAllen.com.
The Beasley Allen Report with your host, Gibson Vance, and special guest attorneys and legal experts discussing the important legal issues that affect you. This is the Beasley Allen Report. Now, here's your host, Gibson Vance.
Welcome back to the Beasley Allen Report. My guest tonight is the founding member of our law firm and former Lieutenant Governor Jere Beasley. Mr. Beasley, one of my favorite cases, and I enjoy hearing you talk about this, and when you speak at legal seminars or to young lawyers, you use this case as a prime example how we can help individual families, but how we can change the way things are done around the world, and that's the Spivey case.
The Spivey case was a really interesting case. It involved the death of a farmer who was killed when a Kubota tractor rolled over and pinned him, and he was actually literally eaten alive by ants out in the hot July sun. We got into the case and found that Kubota knew that they were having serious problems. They were having rollovers, there were deaths, not only with Kubota, but throughout the entire tractor industry. And Greg Allen and I tried the case, and we got some tremendous discovery. We found, for example, that they knew exactly what the problems were, that they had done internal calculations to determine how much it would cost them to go back and put what's called roll bars, called ROPS protection, seat belts and roll bars, how much it would cost them to do it in the future, but also what it would cost to go back and retrofit the tractors that were out there without any type protection at all. And they did this calculation, and they decided that it was cheaper for them to pay off settlements and not do the corrective action, and so that brought us to this lawsuit. And the result was that if you go to the Kubota website today, unless they've changed it, they'll tell the entire world that they've led the industry, the tractor industry, in providing ROPS protection, which includes roll bars on their tractors.
You know, I want to back up to something you just said, Jerry. It's remarkable, and to our viewers, I'm sure they find it fascinating, that you were able to discover, through discovery, a document that clearly showed that they put profits over the safety of people. It sounds kind of like a John Grisham novel or some type of lawyer movie you'd see, where you have a document that says, from an economic standpoint, that it's cheaper to allow a dangerous product to remain on the market than it is to fix it. And we'd rather pay the results of the lawsuit. And we're showing a document here. It's not that document, but it was an important document in the case.
In fact, the document that we're seeing, it actually talks about punitive damages that would be awarded, and punitives are only awarded when the conduct is either intentional or so reckless that it puts human life and safety at risk. And in this case, we actually had documents that showed that a safety consultant for the company had been fired because he told them that they had to put the ROPS protection on the tractors. And so when that document and other documents were seen by the jury, the case was very easy to win for us. And of course, we settled it on the, I believe, the 5th day of the trial. It had gone extremely well. In fact, we had called their own people as witnesses, their own folks that worked for the company, and we had documents, we had minutes of safety meetings that they had denied the existence of. And so they knew they were fixing to get popped pretty good by a jury that had heard how truly bad they had been.
You know, there are a few folks around the country, a lot less than they used to be, that have heard about frivolous lawsuits or juries that have gone wild. But I guarantee you, if you show these documents to the most conservative person in the country, they're going to realize that the plaintiff should prevail.
Well, the attacks on the judicial system have come about because the powerful corporate interest in this country that make products and design and make products, they know that the regulation that we do in this country is very weak. For example, our regulation of the motor vehicle industry, the automobile industry, is much weaker than Europe. In fact, there's no comparison. And so they know that the only thing that protects the consumer is the judicial system, the court system. And so we have seen attack after attack after attack, and they call all lawsuits frivolous. In fact, they call the Spivey case, when we filed it, a frivolous lawsuit. And once it was over, they realized how badly misinformed they actually had been by the company.
Well, I know you've told this story before, but it kind of, to me, stands out about the quality of people that we represent. You mentioned that this case was settled in the middle of trial, but it wasn't really that easy. They paid a large amount of money, but it took some talking to convince Ms. Spivey to take the settlement.
Well, the offer they made to us was a very good offer for the family, for the widow and all the children, but they had a confidentiality attachment to it. In other words, if you take our money, you can't discuss the case, you can't talk about the amount paid, you can't talk about the documents. In fact, they were going to require that we return all of the very damaging documents, internal documents, to the company. And we went up and talked to Mrs. Spivey and the adult children who were in the room, and I told her what the offer was, and it was a very good offer, and in my opinion, one that she'd have to at least consider. And she asked me, she said, "But Jerry, what do you think my husband would do if he was sitting here and I were the victim?" I said, "I don't know. What would he do?" She said, "He would say, keep the money. If we can't tell the public about how bad this company has been, we don't want to settle the case." I went back and told the lawyers from Birmingham who were representing Kubota, and after about an hour, they convinced the Kubota officials they need to settle the case. And so we had a news conference in front of the Montgomery County Courthouse the next morning, showed them all the documents, and it went worldwide. And the public was made aware of the problem, why it had not been remedied, and the fact that it had not been regulated, And so you saw changes throughout the entire industry.
Well, that's a prime example of how one lady's battle and one law firm's battle can change the safety of a product, in this case a tractor, around the world. Now, another case I know you're very fond of because you got very close to the family was the Jernigan case. Tell us a little bit about that case.
Well, the Jernigan case was probably one that 90% of the lawyers in this country would have turned down. And I'll be honest, if Greg Allen had not been in our firm and have the knowledge that he has and the technical expertise, we might not have taken the case, because this case involved not a frontal collision, but an offset frontal where one vehicle comes in and offset, hits the other one. And the thing that really got us was that the car that should have received the least damage was the heavily damaged car. Our car was heavier, supposedly better from a safety standpoint from the Pontiac that hit our Oldsmobile vehicle. So we got into it and we found out that General Motors had a program called the 2500 program. And they had been telling folks that it had nothing to do with safety, just making it more comfortable for women, making it look better, this type thing. We got into it and we took depositions, and we finally got an engineer to admit that what they had done was to reduce the safety factors in this particular series of cars. And when they talked about 2500, the 2500 represented $2,500 worth of weight, mass they called it, reduction in mass. And the way they reduced the mass, they reduced the strength of steel, for example. There are rails that go down the side of a car called the side rails, and there's also what's called the shotgun rail, which goes over the engine. And what they did here, they reduced the weight of the steel from 40 KSI to 30 KSI, which is a significant reduction. In fact, they not only did that, they actually cut the side rails off right there in the passenger compartment. And these rails are designed in such a fashion they absorb the energy in a frontal collision or an offset frontal. And so we were able to prove that they did this, and the jury returned, if I recall, about a $25 million verdict in the case. The young man who was sitting in the passenger compartment was a child who was an honor student, planned to be a doctor. That what's called the A-pillar, the entire frontal part of the compartment crashed.
I believe we have a picture.
Yeah, we do. In fact, it shows how the right side of the vehicle, the right front, the A-pillar would be the pillar that comes up right in the front part of the compartment. The entire, you see the car here, it just was crushed, and he's inside that front, and he received a significant brain injury and was disabled, and his life was changed forever. And the family hired us, and we were able to, Greg Allen and I again tried this case, and it was one that really you'd realize that this family was taking on a monumental giant and had the courage and the backbone to do it. And they exposed the program they call the 2500 program was a fraud on the public.
Well, the bottom line is, after you see the pictures, it showed that they took away a lot of the steel reinforcement where they could make it cheaper, or they could make a higher profit. And although it was a very severe collision, our client, the passenger, would have been okay if it had been reinforced the way it should have been. And in fact, we have a picture of the vehicle that hit our vehicle. It was, as you said earlier, a lighter vehicle, and yet the driver was able to walk away.
That car, the driver did walk away with, I think, maybe scratches, may have had a scratch on the knee, and that was it. And you would expect the damage to have been totally reversed insofar as the damage, the deformation of the steel. You mentioned the cheaper part. It was not cheaper to the consumer. It simply allowed General Motors to make $2,500 more on each one of those Oldsmobiles that they sold in this country.
And y'all proved this at trial. I think we have a diagram of a Volvo vehicle. It is absolutely possible to make a safer vehicle.
They call it the safety cage, and that's what we're seeing right here. This is what a vehicle should have, and with that particular structure, this young man would have walked away also from this wreck with minimal injuries. In fact, it was one that everybody should have walked away with no injuries. And this points out what could be done, what should be done, and many cars do that. Many today still don't do what they're supposed to do.
So a lot of times it has more to do with the way the car is built than the act itself or the collision itself.
There's no question about it. In fact, there was in the side panels, in the doors, there's steel in there that it's supposed, at that time, was supposed to help you in the case of a side impact. General Motors had actually reduced this from about this width to less, almost like a pencil. And
I think we have a picture of that.
We may have a picture of that too.
Oldsmobile 98.
In fact, this is what they changed. This would be the Oldsmobile involved in this case, and it shows the orange. That's actually steel and metal, and it should be 12 to 15 inches from top to bottom, as you'd see in this one right here. Right. The Mercury, which was a 1993 vehicle, 3 years prior to the model of the Oldsmobile involved in this case, that's what it should have looked like.
Well, that's a very interesting case. We're going to take a short break, and we'll be back to talk more with Jere Beasley.
The Beasley Allen Law Firm, helping those who need it most since 1979.
Well, we recognize that our clients come to us because something tragic has happened as a general rule. And we also understand that for these clients, what we do is probably one of the more important things that's going on in their lives at the time. And we have to take that obligation to represent them seriously, and we do. We make sure they understand that we're working for them and that they are important. And we do our best to do everything we're supposed to do and make sure that their interests come first. And we have an ethical obligation and a moral obligation to help those folks through some very tragic events. I'm proud of what I do. I mean, you know, there's a lot of criticism about what we do. I'm proud of what we do because what we do is important to individuals and it's important to society.
Helping those who need it most since 1979. The Beasley Allen motto not only applies to the clients we serve, but also to our community. With an award-winning website at BeasleyAllen.com, the firm provides up-to-the-minute information about consumer issues, including recalls, alerts, and other public safety updates. Potential clients learn more about issues related to their case and gain direct access to our attorneys. See how Beasley Allen has been helping others at BeasleyAllen.com.
Welcome back to the Beasley Allen Report. Once again, my guest tonight is Jere Beasley, founding member of Beasley Allen, started 35 years ago. We were chatting during the break about a case I remember well, the Johnson case, involving a pickup truck, and it was a tragic story about the pickup truck stalling. Tell us about that case.
That was one that it sort of, in a way, sort of like the Toyota cases now in a little bit different context. The Toyota problems deal with a computer system with software. In the Johnson case, it was a brand new pickup truck that was going through an intersection. This was years ago in Marengo County, and a grandfather had his grandson in the vehicle with him. He gets into the middle of the intersection, and all of a sudden the car stalls. He tries to crank it back, can't crank it. Log truck comes over the hill, sees the truck, pickup truck, and thinks it's going to exit the intersection, doesn't slow down, and ends up hitting the pickup from the side, kills the young man, the grandson. And we found out in that case that the problem was a computer chip, and they had problem after problem. In fact, we in discovery, again, where you get documents, we found that they had over 200 or 300, I believe it was over 300 consumer complaints to the dealers And we had documents coming from the dealer to the home office. We had other documents coming down to the dealers telling them that if somebody comes in with this problem, we call it a silent recall. If they come in and complain about the vehicle stalling, take care of the problem, and if they ask you to pay for it, pay for it. If you don't get asked, don't make them pay. But long story short, that was my first experience with what's called a silent recall. And they knew that they had this problem. They knew that they had had it for approximately 2 to 3 years. We had all these documents where not only the General Motors company and all of their folks knew about it, the dealers knew about it, the only people that didn't were the customers. And this was a tragic incident. We tried the case, got a verdict, and the interesting thing, General Motors actually hired a record driver as an expert witness for them in the case to try to claim that the car didn't stall, that the pickup didn't stall. And of course that didn't work, and we found out that the gentleman, we found out simply in cross-examination, found out that he'd been hired by General Motors and he called himself an expert. And but this was a case that shouldn't have happened, and that now everybody knows about silent recalls, and pretty soon they became a thing of the past, generally.
Well, it's kind of ironic. That was probably 30 years ago, the Johnson case, and then you got a big verdict that kind of shocked the nation and sent reverberations around the world in the Toyota case last year. So from the Johnson case to the Toyota case, it kind of spans the last 30 years of your legal career. Jerry, why do you enjoy doing what you're doing, and why, and I hope you'll do it for a lot more years to come?
Well, I plan to do it as long as I'm physically and mentally able to do it. I do it simply because we help people. In fact, the folks that we represent are folks that have a serious problem. It's generally a death or a catastrophic injury, or in certain cases the economic loss in the huge amounts. And the fact that without folks like us, lawyers throughout the country who are willing to take on the giants in corporate America, these folks wouldn't have a voice and wouldn't have an opportunity for redress, and that's why the court system is so absolutely important. And you'll find that both on the federal level and the state level, they underfund the courts. And they underfund the courts because they'd very much like to shut the courts down to individuals, to ordinary citizens who have claims. And that's the only place they can go.
Well, thank you for all you do, Jerry, and once again, thank you for being our guest tonight on the show. That's all the time we have. You can catch the Beasley Allen Report on Sunday evenings after the 10 o'clock news, and on Monday evenings after the news at 9 on WSFA 12.2 channel, Bounce TV. Thank you for joining us. If you have any questions, you can email me directly at gibson@beasleyallen.com. Thank you, and we'll see you back again next week.